Thank you, George, and thank you for the invite. So it's nice having delivered a session to be invited back. In terms of the session, I do recognise some faces, so apologies if we have met in other circumstances. I think that's just about us doing different jobs in terms of courts and otherwise. What I'd like to be able to say is that, in fact, there's been no change in this area of law, and it would be nice to be able to say that there's nothing really I can update you with. But unfortunately, I can't do that, and just to try and illustrate the point, as George rightly says, there is some interconnecting pieces of legislation, namely around the Mental Health Act, the Mental Capacity Act, and indeed the Human Rights Act, all of which I'll return to shortly. But just as a, for instance, in terms of reported decisions that relate to your area of work and practice, how many cases do you think were reported by the courts in 2011? It's normally about 7 seconds before somebody answers. How many reported decisions? Because in fact there was 130 reported decisions in relation to the world of adults in relation to incapacity. The other thing that I'd like to say is that there's no more change coming, but what we see is that there's no codified piece of legislation in this area of law. What we know is that that's currently with the Law Commission, and we're expecting some revisions around 2013/14. So all I'm saying to you there is I think you need to keep an eye on the developments. Some things I'd like you to think about as we move forward is something that George raised with me this morning, which is that there may be people here that are carers or looking after people with HD, and their issue might be around what are their rights in relation to services and those individuals. For those of you that are professionals, what you might want to think about is what's the limitation on your professional role. And if you are doing things for or to people that don't have the capacity to give consent to that, then where do you derive your authority from? Because when it comes before the court, that's what the court will be asking. You've done X, you've done Y, where did you get your authority to do that? And that relates to, I think, 3 key areas, one of which is around decisions and decision-making, so who can legitimately make decisions. The second is around best interest, whatever that means as a concept, because arguably we are making best interest decisions. And the third area is around the issue to do with capacity, and how do we determine whether somebody does or doesn't have capacity. And again, one of the things I'll hopefully illustrate, just to make the point, is that those areas are live issues to the extent that they've been dealt with by the courts all the way up to the Supreme Court within the last 2 years. Okay, so it's a topical and a lively area. The one thing that I would also flag with you before I get into looking at any materials is the issue around your world versus maybe my world. And it was best expressed to me when I was delivering with a care colleague, and his introduction was to say that he lives on planet care. And the way in which decisions are taken in planet care might be something to do with dealing with grey areas and ambiguities and difficulties. Yet when it comes to making decisions in the world of planet law, which is where he was saying I lived, then it tends to be a bit more clear-cut. What I think he was really saying is I live on another planet, but that's... So all I'm trying to highlight for you there is that there are tensions between your decision-making and the fact that when it does hopefully never get called into question, then there will be quite a forensic analysis in relation to what happened and what the decision-making process was. Okay, that's all I wanted to say, as they say, by way of initial introduction. What I set out in the abstract for this session is that clearly there may well be, for many people that are suffering or indeed caring for people with Huntington's disease, a number of issues around how they cope in relation to their work, their social life, their education, or any other matter. And in looking to explore that, an individual, as it is highlighting for you there, may require some level of support or care. And so straight away, we are engaging the law, because the law basically puts some parameters around individuals that are doing things for or to people that are not able to do it for themselves. And as has been highlighted already, that may lead to some extreme intervention, hopefully not, but may lead to extreme intervention, where people may find themselves subject to detention under the Mental Health Act, or, as I've also picked up talking to people this morning, they may find themselves not subject to the Mental Health Act, but in fact they are subject to various forms of restriction on their liberty and what they can and can't do. And the question raised there is, where is the authority for that? So in terms of looking to talk about developments in the law, my reading, and again, quite happy to be shouted down and quite used to being shouted at, told I'm misguided and deluded and ill-informed, which is what happens when you're in court by the judge. There has been, as I say there, an unprecedented change in the law governing adults who are unable to manage their world without some level of support. And I give 3 illustrations. Human Rights Act, amendments to the Mental Health Act, and critically, the introduction of the Mental Capacity Act in 2007/9. And again, what we find is that there is an interconnection between those 3 pieces of legislation, and they all talk to each other. And they have critical application on a day-by-day basis in relation to care for people who are not in a position to care for themselves in whole or in part. Just a brief reminder, because I'll return to Human Rights Act shortly. Mental Capacity Act. What is it? Why is it there? As I understand the Mental Capacity Act, it basically is a piece of legislation that provides a codified framework for decision-making for adults who don't have the ability to make those decisions for themselves. And as it says there, it provides that statutory framework to protect those individuals, particularly where there may be some level of vulnerability. What it also does, as it tells us there, is it makes clear who can make those decisions and in what situations those decisions can be taken and how they should go about it. Because certainly a lot of my work, when I'm approached by relatives or individuals themselves, one of the first things we'll look to establish is where was the decision-making around capacity taken? Had that been complied with in relation to the broad definition of capacity, in relation to the House of Lords decision in 2009? And where is the assessment of capacity in terms of the record? Yeah, and have we truly taken into account what we deem to be best interest? So has there been consideration of the issues to arrive at a decision? Because often when we call the records, which we will, yeah, what we find is that there hasn't been a balancing exercise and a decision's been taken in best interest, which often is around a paternalistic approach. Now again, I'm being deliberately provocative, and you may come back to me on that. But as I say, I do a different job. I don't defend hospitals. I come at this from a claimant perspective. Thirdly, it enables people to plan ahead, which again I think is critical and is where I'd hope to finish this talk in relation to the ability for people now to be able to make decisions whilst they have capacity, yeah, recognising that their condition may deteriorate over time, so that they can have the things happen to them that they would like to have happen as time goes on. And what I'm referring to there are things like advanced decisions to refuse treatment and lasting powers of attorney around personal health care and welfare matters. Yeah, and to allow the people that are around them that they feel safe and loved by to make those decisions for them. But again, interesting area that we need to explore. And moving on, what the Act does is enshrines in a statute what was deemed to be best practice. So on the face of it, there's nothing new to be learned because, in fact, you were doing it anyway. But the question that's being raised is, was that best practice previously, or in fact, was there some practices that maybe shouldn't have been happening? And lastly, what the Act is there to do is to replace the current statutory schemes, as it says, around power of attorney, which I've referred to. So in other words, replacing as was enduring power of attorney and not allowing new EPAs to be taken out. And as we'll go on to see, we have a brand new court in the form of the Court of Protection with a brand new jurisdiction, which is presided over by the Family Division of the High Court. So as far as the courts are concerned, they've taken this very seriously. So that's just a brief reminder about the MCA. In terms of other developments, what we see in addition to the Court of Protection is the Office of the Public Guardian, which again is a very relatively new development, which is there to govern and offer some safeguard with regards to things like your lasting power of attorney. Because previously you could take out an EPA and there was no check or balance on it. Whereas if there is, to use the phrase, impropriety, or put bluntly, some dodgy practice going on in relation to an attorney, in relation to an LPA, then the OPG, Office of the Public Guardian, can step in, and commence investigations and indeed take over conduct of finances and otherwise. We see the introduction of the deprivation of liberty safeguards. And I'll illustrate for you here the way in which the Mental Capacity Act was introduced, allegedly fully compliant with the provisions of the Human Rights Act. But what happened was an individual was in a daycare centre and they were very distressed. And as a consequence of their distress, they were punching themselves in the face and they were banging their head on the wall. And so the doctor was called, and the doctor, rightly or wrongly, prescribed a sedative, bearing in mind this individual didn't have capacity to give consent to that sedative. Sedative was given. He settled a little, but not sufficient, and so a decision was taken to transfer him from the daycare centre to a hospital, which is where he was taken. And in being taken to the hospital, he was kept in the hospital, whereupon the carers who were looking after him in the community said, "We'd like him to come home." And the hospital said, "No, he needs to be in hospital. He's not detained under the Mental Health Act, but we need to keep him in hospital." And so the question then is, where is the authority to stop that individual going home, or indeed for his carers to take him home? Because when the question was asked, there was no mechanism. Because what the hospital said is, "We're acting in best interest, we know what we're doing, thank you very much." Okay? And I suspect that that's not uncommon in some of your areas of work. And what the court said, when it goes all the way up to the European Court of Human Rights, is where is the procedural safeguard that's in place to protect adults without capacity in that type of situation? Yeah? So it's not just an issue to do with psychiatry and mental health, because you could have somebody that goes in for surgery, suffers post-operative amnesia. Yeah, very, very vulnerable, and they want to go off the ward. Yeah, what does a hospital do? Can they stop them from going? If so, where's the authority upon which you're going to be acting? Hence the reason we see the introduction of the deprivation of liberty safeguards, by the United Kingdom, following the ruling by the European Court saying that there was not a safeguard in place. Okay? And that relates to any individual who is aged. There's a question. What's the age limit for doles, as distinct from the age limit for MCA? 18, yeah? Whereas MCA is 16, okay? So if you've got people in that under bracket, you may have some anomaly. And we see linked to the issue around safeguarding and deprivation, a rapidly growing area of practice, not least in relation to a number of high-profile decisions, in relation to Manchester City Council, in relation to Cheshire West Council, in relation to the London Borough of Hillingdon, where decisions have been taken by authorities to act in best interest, and determine that somebody is not going to be returned home having been taken away. And all that the relatives have said is, I understand what you've done, but where's your authority to do what you're doing? Because surely, the state, i.e. the local authority, cannot just go along and take somebody from their home and place them in residential or hospital accommodation. And that's what we've seen in those cases, namely the case of G and Manchester, case of Neary, whereupon at the point that the father and the family is saying, I want my son home, and they're saying, no, we don't think it's in best interest, what do they then do as the authority? They convene a best interest meeting. And what the court said is it's too little too late, and that's window dressing, which links to the other critical point in all of this, is where does the family get engaged in the process? As one of the key issues around care planning, and in particular the engagement at that point of the provisions around Article 8 of the European Convention on Human Rights, i.e. right to privacy and right to family life. Okay, so that's just a little bit of an introduction to developments in the law, and all I'm trying to highlight for you is the interplay between the different pieces of legislation, namely the Mental Health Act, of which we may be detained, or we may see guardianship, or we may see people living in a community, which is an increasing trend. And again, it's a trend that's being pushed, not least because of what's happening in other parts of the UK in relation to the greater use of community treatment orders. We see the interplay with the Mental Capacity Act, and within that, as we've already identified, deprivation of liberty safeguards. And over to your left is the provisions that we've referred to already around the Human Rights Act. And the main articles that I'd refer you to that get engaged in this area of work is around Article 8, as alluded to, family life, Article 5, right to liberty, and Article 3, which deals with issues around degrading and inhuman treatment. I pause there because I know that the Human Rights Act is quite topical at the moment in the press and with the current administration, and the issue is whether it should be repealed or removed or otherwise. And I just raised the question with yourselves, which is, where does the Human Rights Act come from? Because what we need to remind ourselves is that the Human Rights Act is drawn down from the European Convention on Human Rights. And it was agreed by the European nations post-World War II to create a convention to stop any individual member state producing domestic legislation that would allow for a member state to infringe an individual or a group's human rights, in light of what happened in World War II. So on that basis, if we are going to withdraw from the convention, that raises some very serious issues in relation to where it came from. The fact that it took us 50 years to implement, bearing in mind we co-drafted it in 1950 with the French, might be some indication, but I'll leave that with you. So, interplay between all three, okay? And within certainly the MCA and the Mental Health Act, there are codes of practice, which again raises a point that I was very interested in to listen Dr. Quarrell this morning around the issue about rules and whether rules are there in part to be followed most of the time. And codes of practice, and such like. Because as I had a brief private conversation, there have been some cases that have gone up all the way to the House of Lords, on the status of professional codes of guidance and whether they're there to be followed or not. yeah, as a matter of law. And certainly what the courts have said is that the general rule is that they should be followed, yeah, unless you have got good reason to depart from them. Yeah, so it's about being able to document why you've not followed it. So there you have the three pieces of legislation: MCA, DOLS and Mental Health Act. And in summary, some would say that the MCA is actually quite clear to follow, and in particular the code of practice that sits behind the MCA is certainly a very useful and easy read. And what I would refer you to by way of assistance is in particular Chapter 6 of the MCA Code of Practice, because it talks about things that you can do as professionals, yeah, for and to people that don't have capacity. Whereas before, if there was a challenge, you'd have argued that you were operating under common law. Yeah, whereas what Chapter 6 now says is, in fact, Section 5 of the Act will protect you, yeah, because it's designed to protect professionals as well as carers, as well as the individuals being looked after. And in particular, pages 95 and 96, yeah, where you'll see a list of things where it gives examples of the sorts of things that you can legitimately do. Okay. So, what types of issues might present? I suspect care packages is one area that may present as challenging. And I illustrate that with the case of MacDonald, which some of you may better know as the ballerina case that went up to the Supreme Court, yeah, where the individual who was regarded at one point as being one of our best ballerina assets is now in a position whereby she requires assistance, particularly at night, in terms of using a commode. She's not incontinent, and she was asking for a night assistant to be able to lift her off the bed to use the commode. And the local authority said, we don't have enough money to be able to provide you with that, and unfortunately the best that we can offer you is incontinence pads over an evening. Yeah, bearing in mind she wasn't incontinent. And that went up to the, as was, House of Lords, now the Supreme Court, and the Supreme Court endorsed that decision, surprisingly, with one dissenting judge, which was Baroness Hale, yeah, as a legitimate response to a financial situation, yeah, which begins to raise a number of interesting questions. The other interesting point that we've touched base with is around capacity, and in particular how that's defined and how that's assessed, not least because we now have a statutory definition of capacity or incapacity, yeah, as distinct from a definition of mental disorder, yeah, which talks about a disturbance in the functioning of the mind or brain. And we also see, as we've highlighted already, decisions being taken by the courts at the most senior level in this country as to what do we mean by capacity. Yeah, that was a case involving a woman who was 24 with a learning disability, who was invited to be engaged in a sexual act with an adult male with capacity. And when the authorities were alerted to the fact that that had happened, the question that was raised is, did she have capacity, given that he was now being pursued for a criminal conviction for unlawful sex with a, to use the legal language, a moral defective? And what the criminal court said is, yes, she had capacity and therefore was in a position, wasn't in a position to consent and therefore was convicted, goes to the Court of Appeal who overturn it, and then it goes up to the House of Lords. And the question was, did she truly have capacity to understand what she was doing? And whilst she may have had capacity around the act in terms of decision specific, questions that the court raised is, well, what about the context within which that was taking place? Yeah, issues around risk of sexual transmitted diseases, risk of pregnancy. Yeah, did she truly understand the consequences of that? And what the court said is, in their view, no, she didn't. Yeah, so it has to be decision specific, but within a context. The other point that I've touched base with already is in relation to best interest and issues around consent. And again, it's a critical area linked to the issue around how much involvement do family members have? And can, in fact, they be the decision maker, in relation to an incapacitated adult? Particularly if they're next of kin. Do you take that into account? They can't consent. They can't consent.
Take their view into account, but they can't give consent they can't be a proxy for consent.
You've shattered all my illusions about Holby City, ER. Where the good doctor comes out and asks the relative what they should do. Okay, absolutely right. Next of kin has absolutely no relevance. The only relevance it has is in the area of wills and probate. In relation to whether somebody dies without having made a will, and therefore, if there's money left in the estate, then they will seek to identify next of kin. Which is an area I'll come back to. But critically, question for you, if there is money left and there isn't an identifiable next of kin, where does the money go? Anybody? It goes to the Crown, not the government, to the Crown. And in each locality there will be an identified individual. Where I live in Manchester, it goes to the Duchy of Lancaster. In 2009, how much do you think went to the Duchy of Lancaster in unclaimed intestate money? £22.5 million. Okay, which is why it is of critical importance, in terms of forward planning, that you make a will. Not least, and again I stress the point, because as far as the law is concerned, the law is literal in its interpretation. So the guy that left a will saying, I leave all of my money to my son, and he died with about 85 quid in his back pocket and no other cash, and a property worth £140,000, what did the son get? 85 quid. So just a point to bear in mind. Okay. Good job you didn't do it the other way around. I thought you'd have been swearing at me then. Okay, so can restrictions be imposed on a person's liberty in best interest? The answer in short is yes. But again, the point to bear in mind is the distinction between restriction versus deprivation, and the pendulum that operates between the two. And again, the reference point I take you to is the case of G versus Manchester City Council. Capacity and advanced decisions to refuse treatment. Again, what I would be stressing people give serious thought to in this area of law is the need to look at the options whilst they have the ability to forward plan around advanced decisions and make sure that they're properly made out, and also exploring the issues in relation to lasting power of attorney and not confusing that in relation to the provisions of enduring power of attorney. LPA gives various protections, and they can be there for money, they can be there for personal welfare, and also for healthcare. And it means that the attorney doesn't have to be a lawyer, it could be a relative, it could be mum, dad, sister, whoever, is able to make those decisions. I'm probably best to hold it there. I might take any questions if there's anything from the floor. Presumably people will be able to access these materials if they so wish. Any final points before I'm escorted off the premises? Your good self.
Thank you. At the moment, a state initiative, as I understand it, is to transfer elderly people who've got care packages in the home from typical care being provided by the local authority to give them a personal budget, and then they use that personal budget to provide their own care. If the person is elderly and doesn't have the mental capacity to be able to go through all the forms with it, but you have to fill in the forms, you have to write a plan, it has to all be approved, it has to be signed off.
Okay.
And they haven't got the mental capacity to do that. Who is responsible for assessing that person's ability to be able to have mental capacity? And if it's the local authority who say no, they haven't got the ability to do it, must they keep a record of that, which is available to the relatives?
Could you repeat the question? Good technique if you're ever in court. Yeah.
Oh,
I'm
sorry.
joking. I'm joking. Yes, there must be a record, but if the individual's not got capacity, then who's the appointee? Yeah, the local authority must be identifying an appointee.
Yeah, in this particular instance, I and my brother have enduring power of attorney.
Means nothing.
Means nothing, doesn't it? That's right.
Yeah. You should be saying to the local authority, yeah, are they in a position to allow you to take on the role of appointee, to manage her money? But the other point that I'd raise is, if you're ever talking in a conference, talk hypothetically, yeah? Because if a case does end up in court, then we're all potential witnesses to the discussion. Yeah?
My apologies, sir.
Okay, I'm obliged.